Greetings and welcome to Wisconsin in Focus, powered by the Center Square. I am Dan McCaleb, Vice President of News and Content of the Franklin News Foundation, publisher of the Center Square Newswire service. Joining me today is Benjamin Yount, the Center Square's Wisconsin correspondent. How are you, Ben?
Getting ready for holiday party season. I got my first invite. So speaking of which, when's the Center Square Christmas party? Where are we going to meet up for that?
Ben, the Center Square staff is essentially spread out across the entire U.S. From a financial standpoint, holding a Christmas party in a single location, flying everybody in, putting them up, it just doesn't make a lot of sense. We like to put our money into our journalism. Great journalists like you, Ben.
Boy, that's a boss answer if I've ever heard one.
How'd I do, guys? Ben, we're recording this on Thursday, December 7th. A Dane County judge this week ruled that an 1849 law that just about everyone thought banned most abortions in the state pre-Roe v. Wade. The judge actually said that is not the case. Judge Diane Schlipper now says the law does not apply when a woman agrees to end her pregnancy. I've got to say, Ben, I'm confused about this ruling and what it means. Please do explain.
Yeah, the actual specifics of the ruling are a surprise. That a Dane County judge was going to strike down this abortion law was absolutely 100% certain. I think that the tact that she took, the argument that she put forward, left a lot of people scratching their heads. So you have to understand and put this in sort of the broader context that this is why, and we'll be saying this over and over and over again over the next 2-3 years. This case is why Wisconsin's race for Supreme Court was a $50 million race, the most expensive judicial race in the history of America so far, because we've got one coming up in 2025. But this is why they spent $50 million to decide who gets to sit on the Wisconsin Supreme Court, because this case is headed for the Supreme Court, and progressives, liberals, Democratic elected officials have been wanting to reestablish abortion here in Wisconsin since the United States Supreme Court struck down Roe. Essentially, what this judge said is that the ban on abortions doesn't really ban abortions. It bans killing a baby, what she calls feticide. The idea of a consensual abortion, where a woman goes to the doctor and says, hey, I'm pregnant. I no longer would like to be pregnant. Please end this pregnancy. That, according to the judge, is not covered by Wisconsin's 1849 abortion law. This is interesting because there are 3 places in Wisconsin that, before the end of Roe, offered abortion services: Milwaukee, Madison, and Sheboygan. The defendant in this case was the Sheboygan County DA, who said he would absolutely enforce the law that could mean jail time for doctors if they performed an abortion. And the judge walked through a lot of legal techniques to strike down the DA's argument and essentially say, no, it doesn't matter, because this is not a law that means what you think it is. Now, the reaction is exactly what you expected. Pro-Life Wisconsin's Matt Sand said the statute itself is entitled abortion. It makes exception for an abortion to save the life of the mother. It is their hope, he said, that this misguided ruling would be promptly appealed. But yeah, this is one of the ones where, when a judge says the law doesn't mean what the law says or what you think the law means, there are an awful lot of people who are left scratching their head.
Ben, forgive me, I'm trying to do the math in my head, but essentially for about 170 years since this law was first enacted, 1849 again, everybody interpreted the law as meaning it banned most all abortions. Now, a Dane County judge says everybody over the past 170 years got the interpretation of this law wrong. That's not what it does. Is that essentially what happened here?
That's essentially what it is. She referred back to a 1994 Wisconsin Supreme Court case that talked about abortion. Again, in the mid-90s, there was an effort to rewrite Wisconsin's abortion laws. There was another effort in the 2000s, and both of them set limits. Again, the judge here didn't talk about just how far Wisconsin's abortion law can go. The interesting part here is that the Dane County DA, who drove this case on Wednesday, so a day after the judge's ruling, said he intends to appeal and appeal quickly. That will take the argument up to the Wisconsin Supreme Court. The DA said that this is not an issue for the court. Sure, the court can decide if this law is constitutional or not, but he said that the court doesn't need to get into the business of rewriting what the law is. The law needs to be written by lawmakers and signed by the governor. And so the judge's ruling, Judge Schlipper's ruling, strikes down Wisconsin's 1849 abortion law and allows Planned Parenthood to continue offering abortions in Milwaukee and Madison, but it doesn't set the parameters. It doesn't say, well, you can have an abortion up until this or up until there, or this can happen and that can happen. That question remains open, and I'm not sure that the Wisconsin Supreme Court is going to answer that. And so that sort of limbo of, okay, well, what is the law? That's going to be the next question as we go forward. But I don't expect to have to wait very long. I expect the Supreme Court to take this case up as quickly as they possibly can, issue a ruling as quickly as they possibly can. And there's a whole other political conversation to come after that, but that's probably for a different podcast on a different day.
And I'd be happy to join that one, Ben. Final question. We're almost out of time. When you hear people complain, usually conservatives, about activist judges sitting on the bench, that's essentially this was an activist judge making a decision, reinterpreting or rewriting a law. Does that argument fit? Am I off base here?
You are 100% correct that this was a judge that didn't rule on the constitutionality of this 1849 law. She had to find a way to say, well, it really means this. And keep in mind that killing a baby, and I know that for a lot of pro-life folks, an abortion is killing a baby. But if you were to go and find a 6-month-old and stab it, that's homicide. That's already illegal. That's completely and totally illegal. That's been illegal since 1849 up until today. And so to interpret an abortion statute as really meaning you can't murder live children, that's a stretch. But again, with this new liberal majority Wisconsin Supreme Court, there are an awful lot of conservatives in the state who say it doesn't matter what the argument is. The whole exercise is to get the case to the court so the court can then issue a ruling. And again, it will be based on the Wisconsin Constitution. So there will be likely very little chance to take this to the United States Supreme Court and get some relief there.
Well, this is another one of those cases, Ben, that is not going away anytime soon. Look forward to your continued coverage of this issue as it works its way through the court system, but that is all the time we have today. Listeners can keep up with the story and more at thecentersquare.com. For Ben Yount, I'm Dan McCaleb. Please subscribe. Thanks for listening.
Knowledge is power, and you deserve to know what happens in your state government. That's why the nonprofit Franklin News Foundation is bringing you straight news journalism through the Center Square, reporting on state authorities and publishing stories that show where your money goes and who spends it. By supporting the Center Square, you can track politicians' use of taxpayer money and demand transparency from elected officials. This is how we can equip everyday Americans to hold their government accountable. Become a supporter of Franklin today at franklinnews.org/donate.